Good evening. This is Rahul Reddy. We are live here from Houston, Texas. Every Tuesday, do bring in immigration updates from 5 p.m. Central Time to 6 p.m. Central Time. Along with me is my business partner, Emily. What do we have today to discuss?
Yeah, we're going to start off talking about the H-1B lottery now that is over and we have all of our selection notice with the filing window is open. What about people who were not selected? What are their options? Is there going to be a second round perhaps? We'll talk a little bit about that. And then we have some recent cases with some kind of strange adjudications that we've never seen before that we wanted to bring to people's attention. Number one is a 485 denial. The I-485 is the adjustment of status based on someone who used CPT, one of these so-called day one CPT schools 15 years ago. It came back to cause issues for the green card. So we'll discuss a little bit of that. And then we've also seen H-1B visa stamping denied at the consulate due to social media vetting when they look online and see Instagram posts that make it look like you're working without authorization, doing things that are not aligned with your H-1B. And we've also seen H-1B denials based on supposed misrepresentation when the work locations are not lining up based on LCA locations and actual living locations where you are working from. So we'll talk about kind of those situations. That just gives you an idea of where we are headed with this whole idea of extreme vetting. It is definitely happening. It's increasing. Again, we only are so far into the Trump administration. We're pretty early into it. And so things are only going to get harder from here.
First one, we have seen that in May visa lottery for Indian nationals, nothing much has moved, but seems that they are only accepting final action dates in the month of May. So I just want everybody to file the application in the April. Emily, with regards to if the H-1B is not selected in the lottery, what are the options people have? I mean, let's say their
Yeah.
STEM extension is expiring, or what are the other options that they have?
Yeah, and just to point out that we do have a webinar on this exact topic where we'll go into much more detail. And that is this Thursday, April 16th at 1 o'clock Central Time. We have added the registration link, so you can go ahead and sign up for that if you're looking for more detail. But if you are running out of OPT time, you can consider enrolling in a new program for school. This is where a lot of people tend to look to these day one CPT schools because they want to keep working. We've said for many, many years that we are suspect of these programs, and our next topic will likely show why. But it might be an option. Otherwise, just going back to school, finishing a new program, updating your skills can be an option to continue on F1. Another option is maybe you can find a CAP exempt employer. These are going to be institutions of higher education, universities, nonprofits that are affiliated with an institution of higher education. Public schools a lot of times qualify for that. Hospitals that are affiliated with the university, teaching hospitals, that sort of thing. Research organizations that are nonprofit. And if you do find one of those, you can also file a concurrent H-1B to work for your for-profit employer at the same time without the for-profit employer making it through the lottery. That can allow you to keep that job until the next lottery rolls around. Possibly moving overseas and working for a multinational company that may give you the opportunity to come back on an L visa after 1 year. Potentially, you could look into a J1 program for intern or trainees. Those are a little bit difficult for people who have already been in the US and got their education here. They might not qualify. There is an H3 visa for training if your employer wants to provide some sort of training that's not available in your home country. That can be for up to 18 months. For those that have maybe a PhD, or I mean, PhD is not a requirement, but high level, we're talking about extraordinary ability, the Einstein visa, the O1 visa, if you can show you're at the very top of your field, that can avoid the need to go through the H-1B lottery. Citizens of Canada and Mexico, depending on the job, might be able to qualify for a TN visa. Citizens of Australia can potentially qualify for an E3 visa, which is very similar to an H-1B, but a lot easier to process, and the cap is never reached there. Depending on your country of citizenship, if there's a treaty between the US and that country that allows for an E1 or E2 visa for traders or investors, that might be an option. If you're married and your spouse is on an H-1B or an L1, you could switch to H-4 with an EAD if your spouse has an I-140 approved, or switch to an L2 and have work authorization. Depending on your country of birth, employment-based green card may be an option to allow you to get through labor certification, I-140, and file the adjustment of status before you run out of your current status. And lastly, family-based green card. If you marry a US citizen or potentially marry a green card holder and are able to file timely to be able to file for adjustment of status. So that's a very quick overview of the options. A lot of options don't, not everybody qualifies for them. So it can be a tough situation for sure.
Emily, why is that there are so many people who go to day one CPT? Still, our office has never advised people to join day one CPTs.
Yeah, I mean, when you have used up your 1 year of OPT, used up your 2 years of STEM OPT, currently it's very easy to continue F1 stay. You don't have to file anything with USCIS. You just get an I-20 for your new program, and now you're continuing because F1s get duration of status. And then, of course, the main draw is with these day one CPT programs that allows you to also work while you are studying. And these day one CPT programs, they don't require you to attend classes very often, maybe once or twice a semester in person. They're very easy to get into. There's no GRE requirement. They don't look at your grades. You can get in any time of year. There's no start time. There's no spring semester, fall semester. So they're very easy to do, which makes them very tempting for people to utilize, but it certainly has potential for long-term consequences. And a lot of those long-term consequences, we don't know yet. I was on a consultation with someone earlier this week where they were asking about it, and, is this something that could impact my green card in the future? And I said, you know what, for the people that have been using day one CPT with the backlog of green cards, most of them have not gotten to the point where they've actually filed their 485. That's just now happening. And so we're just now going to start seeing how these are impacting the green cards. And our next topic was exactly that someone's 485 was denied based on their day one CPT time that was done over 15 years ago.
I just want to let you know, guys, there will be scrutiny at the 485 interview, and there are sometimes scrutiny about the day one CPT. And recently, we got a couple of cases getting denied because working for the day one CPT. Definitely, if there is an interview, probably it may be cautious. Right now, we are advising people to take a lawyer with you along when you go for the interview. A lot of people say, hey, so many people are going to the universities, they say up to 100,000 people are going to the university. So the day one CPTs, why are you advising wrongly? Here's a simple question. No, it's not us doing it. Let's speak about it. There are about 3,000 educational institutions that are allowed to give an I-20. How many educational institutions are giving a day one CPT? Handily, about 7 to 8 universities are giving day one CPT universities. Now, there used to be two more universities, their presidents are in jail, which is Silicon Valley University, and another is called Tri-Valley University. There are also two other universities which are a sting operation. Sting operations is where they pretend they are operating, they will pretend that you will call them, and then you'll ask for some wrong thing, and they will sell the wrong thing, and once you buy the wrong thing, they will put you in jail. And there are two sting operations in such cases in the day one CPT. One is called University of Northern New Jersey. One is called Farmington University. Now, you can Google about these four universities whenever you like to, and you can find the information what I'm speaking about. So definitely, if it's a legitimate thing? Do you think so? The government is going to put an entire sting operation with all the people working together to do the sting operation? I mean, let's assume that you are going to go in on the street and somebody is selling you Coca-Cola. If you buy Coca-Cola, you think so somebody's going to come and arrest you? Most probably not. I mean, that's not going to happen. But if something they are selling a wrong thing, let's say marijuana or hashish or whatever those kind of things that are illegal, and then you buy those things, definitely that is something that's where the sting operation comes in. Police or law enforcement authorities don't pretend to be drug dealers and sell Coca-Cola. I mean, they don't. Believe me on that. Or Pepsi, which are, both the drinks are genuinely be bought by anybody. Even a child can buy those kind of things. There is no restriction that the child cannot buy those things. So definitely those are not the things that they do. So be watchful on these day one CPTs. I know that a lot of people ask, I don't have an option. We still cannot recommend you to go on to the day one CPT.
Yeah, I mean, beyond, the impact, potential future impact on the green card, what impacts we have been seeing over the years, because these are not new programs, people who attempt to go for visa stamping often get 221Gs or their visas denied. We see people have difficulty at the port of entry when they're traveling into the US. I mean, CBP refers to these programs as pay to play programs, meaning you're paying your tuition money to have a job, not to go to school. They know that. And so they are aware of that and watch out for it. And also in the change of status application, later on, when you do finally get picked in the lottery and you file your change of status to H-1B, these day one CPT programs are very highly scrutinized. We've seen over the years many change of status denials because of it. And now a change of status denial has a much bigger impact, because if it's an H-1B, that means they're converting the H-1B to consular processing, which causes the $100,000 fee to be triggered. So it's not something to play around with in the current environment.
Um, we have also seen some people whose H-1B got denied because of the Instagram. Either their visa got stamping denied or the H-1B extensions are getting denied right now because they posted Instagram. Some people have posted that they're doing hairstyling. Of course, and their H-1B says that they're doing a different job. Some people posted as cooks. Some people have posted that they're working as a different thing, though. Now, I know that some of the people may have passionate about, for example, hairstyling. Some people have, like, for example, I like running. I go I do running a lot, run marathons several times for a period of 20 years. And sometimes I do coach running thing. And that's just a hobby though. But maybe for H-1B assemblies, if they posted that they're doing as a coaching, even though it's a voluntary job, I never intend to become a coach of a running. They may take it wrongly though. These Instagram posts are going to get into trouble for the people, where if you express your hobbies also might become troublesome though. What do you say? Where is the limit? Where is the line where we can tell our clients what you can do or not do? For example, I don't consider as running as a work. I mean, if I do some other work, I have to disclose to Reddy and PC what work I'm doing to you, Emily, but I never listed that I'm working as a coach. Is that something? What about the people on H-1B? Where is the limit? What can they do? What is this Instagram or Facebook or YouTube post might get them into trouble, Emily?
Yeah, I think it's one thing to do that activity for yourself as a hobby and post about it. It's another thing to do that for someone else. So if as you mentioned, you're running marathons and you're posting about you running in the marathon, an H-1B worker, I see absolutely no problem with that. But when the H-1B worker starts saying, "Hey, I'm running in the marathon, I can coach you to also get a better time in the marathon." Now that's, could you be seen as someone who's getting paid in order to provide these coaching services. If you are showing off, hey, I did my hair this certain way and, it was really easy and here's my video about how I did my hair this way, that's one thing. But then if you're showing yourself doing someone else's hair, for a wedding or whatever, even if you're not getting paid, that maybe brings into question, are you doing something that normally people would pay someone for and could be considered unauthorized employment? If you are, want to share your recipes online, great. Do it in your own kitchen and say, hey, this is a recipe that I'm doing for fun. It tastes great. But, don't show yourself in a commercial kitchen doing these recipes and saying that, hey, I'll, cook for you or something. So you have to be just that's where I would maybe draw the line, is doing these things for yourself and posting yourself doing them for yourself versus doing them for other people and posting about you doing things for other people. And that
And
might be going too far, but better safe than sorry, because we're seeing denials because of social media posts.
especially if there is any money involvement that you're charging or you would charge, then definitely that may become a problem. Even if it's cooking, even if it's running, even if it's hairstyling or any other thing. And Emily does the financial training too for charity purposes, not that she is making money on it. So those kind of things definitely. I mean, if you are an H-1B though, we are Emily is not, but I'm not. But that may get into trouble though. So we just want you guys to be cautious right now. There are softwares that are dragging all the information about your personal information. Of course, when you go for the visa stamping, you're supposed to disclose it. Even if you're not going for visa stamping, there may be some of your friends and there are some of the neighbors that may not like one of the guy may not like you, and they may actually report it, and it may get to the attention of the USCIS, and they may take in a wrong angle than what you may have posted. So we just want people to be a little bit more cautious when you're posting anything on the YouTube, Instagram, Facebook, or any social media, though.
All right, last topic, H-1B work location violations. How can that lead to a finding of a misrepresentation and a denial of an extension of status?
Emily, there are a lot of times people do not disclose the information where they are. So there are some FDNS visit where people have said they are in New Jersey, but in fact they were in Dallas. And when the FDNS found out that they were in Dallas, though they not only revoked the H-1B or denied in some cases, but they also put a misrepresentation that he gave the wrong information saying that he was in New Jersey while he was in Dallas. And that is where has gone into misrepresentation. That means that they are completely barred forever to come into United States. Um, we First of all, people do not consider that when they are working from home, when they change the location, they think so that, oh, nobody is looking at me. That's the biggest mistake. And whenever you're changing the home, though, if it is out of the MSA or let's say beyond 30 miles of where you are located at, definitely, I mean, you have to file an H-1B amendment. And that amendment has to be done before you move. Oh, you know what? I'm going to go to Dallas and see how it looks like, and then I'm going to file the amendment. No, 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 no. Before you move to Dallas or before you move to any location, you need to file the LCA. You need to file the amendment. You don't have to get the amendment approval. You just have to file it. I mean, you can file, you don't have to do premium processing, and you can get the approval later on. But don't move before the amendment has been filed. Time and time again, we have seen that this is a mistake. People do it and they get into trouble. Previously, when people used to get into trouble, all we were doing at that point of time was probably just have them go to do the consular processing, go to India, get the stamping, and come back. Couple of reasons. Right now, they're issuing misrepresentation. This administration is very tough. If there is any mistake, they're going to issue misrepresentation. To get out of misrepresentation, it's going to be very tough because you then need to hire a proper lawyer, go and fight the entire case, and maybe you have to go to the court. And any failure of this one will be that you will end up with paying $100,000 fees. and then you will have to go for India stamping. No company is willing to pay $100,000 fees. So definitely, it's a very costly mistake if you move to a different location than the current location where you are in, and you did not file an amendment. And sometimes, Emily, they have contacted the employer's lawyer, and the employment was just terminated because they informed the employer. Sometimes, oh, you just speak with the manager. Oh, I already informed the manager. No, that's not enough. I informed the HR. That's not enough. You have to make sure the amendment has been filed before you move to a different location. Don't whine on the manager, don't whine on the HR. It is your responsibility. Here is the problem. If the employer does a mistake, you're going to get hit. If you do a mistake, you're going to get hit. That is how the immigration system is built.
Yeah, and I'll also mention that if you do move, you do need to make sure you update your address with payroll so that your pay statements have your correct address on them, because that is one thing that USCIS looks at 3 years later when you're filing your extension. Is the address on your payroll records matching what is on your LCA from your last petition? On top of that, of course, whenever you move, you're supposed to file the AR-11, and your employer also is supposed to pay the payroll taxes in the correct state where you're actually physically working. So if they're not doing that, the employer can be found to be violating tax laws in the state, which is not an immigration issue, but it becomes a big problem all around. So it's very important that any change in physical work location, even if it's the same job you're doing, even if it's the same end client that you're at, if you're moving your butt from one MSA to another MSA, an amendment has to be filed first.
Anything else, Emily?
I think you can go to questions.
VG has this question. Has a short I-94 overstay on H4 and no unauthorized employment and corrected with a re-entry. I'm assuming that it was just the I-94 correction that happened. If that is the case, though, that should not cause any problem in the 485 filings. And that should not cause any in getting the approval of the 485. And also, 245K exception, where if a person is not in status for less than 6 months, if it's an employment-based green card, they should still be fine. But definitely check with the immigration lawyer to make sure everything is okay.
Discover About 73 says in fiscal year 2024, the H-1B was picked. The I-129 was approved for consular processing, meaning no I-94, no change of status. Never got the visa stamp and wants to know, can I do a change of status now to H-1B from within the US? If the same employer who filed that H-1B is going to do that and the petition has not yet expired, yes, that can be done. However, if you're trying to do this with a different company or that petition has expired, no, you are considered to be subject to the cap. You have not been counted yet. Getting that consular processing approval does not make you counted in the cap. You have to get the visa stamp in order to be counted in the cap. So in most situations, no, you cannot take advantage of that old H-1B.
Question that is coming for Papi. His I-140 and 485, both are pending for more than 6 months. Can he now change the company and still claim the AC-21 and get the green card? Technically, the answer is yes, but practically, I will advise you against it. I want you to wait until I-140 is approved. If you can convert into premium processing, I-140 do premium processing, because we can, once you leave the company, what if the company withdraws the I-140? Then what will happen is that we will have to prove that the I-140 was approvable at the time of the 6 months or at the time of filing the I-140. Now, you can hire us. We can fight you until your last drop of your blood is there. We're going to suck it up, and we can go to court for you and do all those things. It's going to be very expensive. My advice to you is that don't do that. Wait until I-140 is approved. Now, once the I-140 is approved, though, since it's been more than 6 months that you filed I-485, you will be perfectly all right. to change the job within the same field?
Sai says, my previous employer has withdrawn my I-140. The priority date is 2016. If I join that previous employer, can they then file the I-140 again without filing the perm labor certification? And if so, what are the conditions? Yes, they can. They simply use, assuming that the job offer that's on your labor certification from 2016 is still available to you under the same terms and conditions, same work location, all of that. Yes, they can simply refile the I-140 using that old labor certification. The big if is, are their taxes looking good? Because you have to, that company has to show that they had the ability to pay the wage mentioned on that labor certification from 2016 all the way to 2026. That's 10 years worth of tax returns, assuming the company has fewer than 100 employees. If they had 1 year where you were not working there and their net income is below the offered wage, or their net assets are below the offered wage, maybe the COVID years, people had rough times financially, the refiled I-140 can be denied. So you definitely want to make sure that company has had their finances vetted to see if they can withstand 10 years worth of scrutiny on the ability to pay issue.
Abhilash has a minor car accident where the other driver was injured. Is that going to affect his future H-1B and green card? I'm not expecting any problem in getting the H-1B extension approved and also for the green card. However, depending on the criminal the ticket that they might have given, you may have to disclose that information. And sometimes in instances of H-1B extension, they may also ask you to come for the biometrics. You need to also make sure that the case details, you keep it properly. And if there is anything, you can get the certified copies, especially the dismissal of the case. Dismissal means it can be after you pay a penalty or whatever it might be. If you can get that thing certified copy, and when you get that certified copy, go ahead for me, make it 6 certified copies because you may need it until you get the citizenship. But no, I'm not expecting any denials of the H-1B extension, or definitely not a green card denial. I'm not expecting it, but there may be some slight hurdles that you have to face.
Lucky Luck from Facebook says, can you advise for a child on H4 who's going to complete their second year of their undergrad and wants to move to F1? What is advisable and best practices to follow? So they need to make that transition before they turn 21, or that's the deadline, is when they turn 21. If they want to be able to do any kind of internship, CPT, OPT after graduation, they may need to make that switch sooner. I recommend filing a change of status on the I-539 versus going for visa stamping right now. With that change of status, they are going to need the I-20 from the school. They're going to need to show that they've been maintaining their H-4 status, which also means you show you're maintaining your H-1B status that is dependent on. They need to show that they have sufficient funds available to pay for their tuition and room and board and all of that for the first year. They need to show that they have a residence abroad that they do not intend to abandon. And they need to show that they intend to return to their home country at the end of the F1 program. All of that should be included with the I-539 application.
MOH from YouTube has this question. He has some spelling mistake in birth certificate. Will that cause any problem in the 485 application? His passport and other documents have the correct information. I'm not expecting much problem for you, because what happens is that when you write an English language, when you write other languages in English, though, you write it differently. And I'll tell you one thing, though. Simple example of Muhammad. My goodness, there are 140, 50 spellings of Muhammad. So, and people may write it differently. You may have it passport differently. So, the only thing that I would recommend is if you can have that other names used in the 485 application, then it will be fine. If the spelling is like, for example, if it's Sandhya, and the spelling of it is, and the name there is sounding as uh, Sweta. I mean, that's a completely different name, though. But if it's a word here and there, I'm not expecting any problem for you.
Siram says H-1B expired December 2025. The extension was already filed in November, but the CBP gave the wrong I-94 validity and gave an extra year till December 2026 on the last entry. Now he's got a new job offer and wants to know if the new employer can leverage this I-94 validity. No. Never rely on a USCIS error that's in your favor or a CBP error that's in your favor. You need to go by the December 2025 end date. And because that has already passed, that means you need to get the extension approved with your current employer before you're eligible to transfer. Because if you do file a transfer and maybe the old employer gets an RFE and they don't want to respond because you're no longer with them or they know you're leaving them, they could just withdraw. That's going to trigger the new employer's transfer to be converted to consular processing. That's going to trigger the $100,000 fee. And I'm pretty sure they're not going to want to pay that for you to leave to go for visa stamping and not come back. So, no, definitely not a good idea.
Me and my wife have renewed the H1 and H4 respectively. Wife needs to travel to India. Can she go for visa stamping based on the 797 without me traveling? Technically, she can. Technically, she can. However, there are no visa stampings available right now until March or April of 2027. We have seen some emergency visa stampings that have been issued, unless there are very rare situations that are issuing a visa stamping. But it's we are advising people not to travel at all. But technically speaking, about she can. And my advice to her is please do not travel unless you want your husband to get a new wife.
Meenakshi says, I have my EAD valid until December 2027. My husband is changing his employer. Should I also apply for my EAD extension since he's changing employer? What's the time frame for EAD approval? So although you don't have to, I definitely recommend it, especially if the employer is willing to pay for it and file an H1, H4, and H4 EAD all at the same time. That way you can very likely get your EAD approved before December 2027 instead of having to wait until June 2027 to file and then potentially file it with the processing times increasing, having to stop working. So definitely, I do recommend filing all three together whenever you're in a transfer situation.
Even if you complete the degree in day one CPT university, will that be a problem in the future? Yes. It may become a problem even if you completed the degree. Because here is the thing, simply understand this thing. A university, that admission is given to everybody. The classes start anytime you want to start. You don't have to go to school at all except for 6 days a week. Sorry, did I say week? That was when I used to go to law school. Sorry. It's 6 days a year, not even month. So definitely all that is not sounding good. So it may get into scrutiny. And believe me, guys, 95, 98% of the university don't do that. You go to University of Texas, University of Florida, University of California, University of Oklahoma, and Oklahoma State University. All those universities, they don't give day one CPTs. So definitely we advise people to stay away from it.
Satish says he's been an Immigration Girl follower since 2010 and been following this channel from the beginning. He filed a 485 delay lawsuit through Stephen Brown in our office, and he got his green card approval last week. Congratulations. He says, best money ever spent. Peace of mind is priceless. Well, congrats, Satish. That is great news. I'm sorry you had to go through all of that to get your approval, but definitely go out and buy some champagne and have a glass for me because that's amazing.
Emily, why don't you explain me what this AOS delay lawsuit, but Stephen does it every day for so many people. What is this, and what is the misconception is if you file a lawsuit against the government is going to take a big bazooka and will come after you. Is that true?
Thankfully, no. So every single federal government agency is subject to the Administrative Procedures Act. And the Administrative Procedures Act, or APA, has a provision that says that any government agency, when it's supposed to act on something, has to do it without unreasonable delay. So they can't act arbitrarily. They can't deny for no valid reason. They also cannot delay the application for no valid reason. And so with these 485s, when they're pending forever, the priority date's current, you've done everything you're supposed to do, we're able to file a federal lawsuit under the APA claiming that your 485 approval has been unreasonably delayed. Now, when we file that, we are not asking them to approve your application. We're simply asking them to adjudicate it, to give us an answer one way or another, because it's been unreasonably delayed. When we file those, the government does have 60 days to respond in court. You don't have to go to court. We file everything electronically. And government typically will look into the case and determine whether maybe there has been a delay or not. But a lot of times it just gets things moving so that we do see that approval. And the government is not allowed to retaliate against you. They cannot deny your case. They cannot delay your EAD. They can't deny your H-1B or things like that because you filed a lawsuit. It's your right. Even though you're not a US citizen, you also have the right, because you are dealing with a federal government agency, you have that opportunity to use the courts just like a citizen does, and they're not allowed to retaliate, and they don't retaliate. So it is one of the only ways now to get the case moving and get the case adjudicated, because we don't have an ombudsman functioning anymore. We don't have, I mean, we have liaisons with the different congressional offices, but they're not really able to do anything because USCIS just tells them, oh, it's within the normal processing time. So there's nothing that they'll do, even when the normal processing time is 4 years. I mean, that's like judging a snail's race, as one of the cases Stephen dealt with talked about.
Emily, you said the online processing time says 4 years. Do I need to wait for 4 years before I file the lawsuit?
No, you don't. We typically file when it's been about a year and a half, and you don't have to wait until the priority date's been current for a year and a half. We're looking at total processing time of the 485.
Question from Sean Kapadia. He has a visa stamping until 2027 with company A. Can company B file a consular processing and he doesn't have to go for visa stamping, and he enter with company A's passport visa stamping with company B's H-1B approval? The answer is yes, but there is always a catch point for this. The company B, if they want to file a consular processing right now, the company B has to pay $100,000 fees to file the consular processing. Yes, if the company B pays $100,000 fees, gets a H-1B with the consular processing, definitely you. And a passport stamping is still valid with company A. You don't have to go for visa stamping with company B. You can come into United States.
Naresh says, we filed my spouse's H4 and H4 EAD October 29th, 2025. Her EAD expired February 22nd, 2026. She has a job offer starting May 4th. Please advise any options. So I'm pretty sure USCIS is going to say it's still within the normal processing time, which is ridiculous processing time. So litigation is going to be the best bet there. You could try an expedite request showing she has a job offer, but they can't expedite anything these days because everybody needs to be expedited. So yeah, litigation, reach out to Stephen at rnlawgroup.com.
Second. People are asking with regards to the visa bulletin, there is no advance in the final action dates. Definitely, that's not a good sign. But anyway, the dates have moved a lot in the past 2 months. So definitely, there seems to be a break on it. There is a good chance that the dates may not advance that as much as what it has advanced previously, where it did advance for almost 1.5 years in a span of just 2 months. So definitely, we're not expecting very spectacular moment in there. The other thing is that the USCIS, when said that it's the final action dates that they are going to consider starting from the month of May. So, which is not a good sign because until April of 2026, though, they're going to consider the filing dates. But when it comes to the May of 2026, it is going to be final action dates. So, which is not good because those people who want to apply, they cannot apply in May. So, please, if your filing date is current in either EB2 or EB3, don't wait until May. File it right now.
Brajesh says, my perm and I-140 are approved for Connecticut work location, but we don't have an office in Connecticut anymore. How can I prove that I will be working in the same MSA as the perm? Um, Assuming that the perm did not say that work in unanticipated locations was allowed, you may not have an option to use that perm, because if the company said that you were going to work in-house in their Connecticut office, and now they're saying that you're going to work from home in Connecticut so that you can be in that MSA. Well, that was not an offer made to US workers through the perm process. They were not given the opportunity to work from home. That can be considered a negative factor and make that perm no longer viable if the actual office location is not there anymore. So you may have to go through the new perm process or look into NIW or EB1A where you can self-sponsor.
Question from Dreamer. He has company A's visa stamping, visa stamping. Then he moved to company B while in USA. Now he's moving to company C. Can he travel out of USA? First thing is you better get the company C's H-1B approval. We advised you not to travel, but if you don't follow our direction and want to make us rich and make you poor, then definitely, technically speaking, about since your visa stamping is already valid with company A, even though company A has withdrawn the H-1B, you can still travel if you have the company C's H-1B approval. When you come back into the country, since your passport visa is still valid, you have to show the H-1B approval of company C. You have to tell them you'll be working for company C, because sometimes what they do it, oh, you're just coming in, they just give the visa stamping. Based on the visa stamping, they give an I-94 until company A. And you have to make sure that you have to get an I-94 until company C's H-1B approval. But still, my advice is not to travel.
Krishnavani says, I had my 485 employment-based interview a year ago, submitted my medicals during that interview. Priority 8's been current for 4 months. I submitted a supplement J recently, and still an RFE's been issued. Haven't received it yet. Are you seeing a lot of RFEs for issues other than regular medical RFEs? So most common RFEs that we're seeing right now are medical exams expired or provide us with an updated supplement J. I know you mentioned you filed the supplement J recently, but I have had cases where we filed the supplement J and then turned around and got an RFE asking for the supplement J. So it could simply be asking for that. Beyond that, it could be anything based on your background. It could be, prove to us that you maintained your status during a particular time frame. It could be something related to the birth certificate. It could be, they see multiple different versions of your name used in the past. It could be almost anything. So just best advice is wait for the RFE and deal with it when you get it.
People are asking questions with regards to the people who have applied for change of status to B2 while they lost their job. Have you seen anything? What's going on? At this point of time, my advice right now, Emily can disagree, but is that don't file the H-1B while the B2 is pending. Wait until the B2 is approved and then file the change of status. And we have seen B2s getting approved. However, when there is another application pending, though, like H-1B, they are issuing RFEs for the B2 saying that, hey, you applied for H-1B. What is your intention there? For H-1B, they're telling wait for the B2 to be approved. So probably the better approach would be is to wait until the B2 is approved and file the change of status afterwards. Emily, anything different?
No, I absolutely agree with that based on the current trend. Sayed says some influencers are doing YouTube videos on with H-1B investigations in the Dallas area to detect fraud. Is there going to be more scrutiny on future H-1Bs? I would definitely operate under the assumption that yes, you can expect there's going to be even more scrutiny going forward on H-1Bs, not just because of these YouTube videos and the like, but just in general with the Trump administration. It's the same thing we saw during previous administration. We expect it for the current administration as well. Again, make sure that you are in compliance with everything specified on your H-1B at all times.
Green card approved. Can I work and flip burgers in McDonald's? Why not? I mean, when I got my green card, yeah, I used to work in Pizza Hut, and then the best thing I loved when I worked in Pizza Hut was I used to get a 25% discount in Taco Bell when I show the paycheck to them, and then I used to eat the seven-layer burritos. Very good. Nothing wrong with it. You can absolutely work and flip burgers in McDonald's just like the way I did in Pizza Hut, and nothing wrong with it. You cannot, you cannot sell drugs or marijuana. Definitely no illegal activity. Flipping a burger in McDonald's or delivering pizza or making pizza, those are completely legitimate things. You can do it even though you got a green card on a software engineer. Can you do it? Absolutely. I don't see anything wrong with it.
Raghu says, does the $100,000 fee apply in this scenario? I'm staying with the same employer who's the current H-1B sponsor, but I'm changing the client after going to India and filing an amendment. So if you are in India when an amendment is filed or when anything is filed, that means it's going to be a consular processing request. The $100,000 fee applies. Anytime the petition itself requests consular processing, the $100,000 fee applies. Now, if you're in the US at the time of filing, and it's filed as an extension of stay with that amendment, generally the $100,000 fee does not apply unless, as part of the amendment, they determine that you failed to maintain status for some reason or violated your status. Then they're going to convert your amendment to consular processing and trigger the $100,000 fee.
Company X filed for a 485. Firm filed my 485J. Um, I got divorced from the firm. He or she requested Firm X to withdraw the husband's case. They withdrew representation. Will that impact the I-485? I don't know if they have withdrawn your husband's case at all, though, because normally they may ask your husband to contact, though. Uh, so what I would suggest you to do it is send a interfiling to your application telling them that you now are divorced. Now, I do not want you to withdraw your husband's 485 application because it's he who filed it. I just want you to interfile so that tomorrow, later on, you will not be blamed for misinformation. Or later on, if you want to file for you get married later on and then you file for another husband, and then later on they may come into, hey, why did not you inform previously? So I would just interfile it by requesting the USCIS, look, my circumstances or my personal circumstances have changed. I am right now divorced. Here is the divorce petition. I just want to update my 485 records. That's the best approach for you. Nav Ready 5 from YouTube.
Herday says, I applied for the H-1B lottery, didn't get selected. Based on the SOC code, I believe it was level 2, and I might be switching to a different role internally in the same company. That would put me at level 1. If there's a second lottery, can they file? Well, with the second lottery, you're automatically entered based on the first lottery submission. So if you're selected, then the company can choose to file. Now, are they going to attempt to file based on the new role, then there's risk. We don't know what USCIS is going to do in situations where there's been a legitimate change to the position. They said that they will understand that sometimes business needs change, but how do you prove that it was actually a business need to make this change and not some way of them actually gaming the system for the lottery? So there's definitely risk there. Doesn't mean that they can't file. It's going to be up to the company to decide whether they're willing to file in that situation or if they're going to put you back in the original role to file the H-1B to be on the safe side.
Srikanth has this very interesting question. I would say question of the day. He's right now working a hybrid. Hybrid means that everybody knows that you work from home a couple of times and you work from office a couple of times. Now they're moving to remote, complete remote, 100% remote. Is there anything to be done? Here is where a lot of miss the point. People miss the point. Where did the LCA pointed out? Where did the H-1B pointed out your location was? When the company filed the H-1B, did it reflected that you're going to be working at home and office? Sometimes, let's say, for example, if you are in Dallas, your company is in Dallas and you're living in Irving. If they posted the LCA in Dallas, Irving also comes within the same MSA. Since you are living in Irving, absolutely not a problem. You can move into, you can do the hybrid job from Irving. That's just perfectly okay. What if the situation is, for example, if you are working in Dallas and your home is in Austin, which is not the same MSA as Dallas, and right previously you were working, you were coming here to work to Dallas 5 days a week. Now, if they are moving to remote thing, that means that you will be working from Austin. That's not allowed. So I want to make sure that your office location and your house location is within the same MSA. If it is not within the same MSA, then you need to check with a lawyer before you discuss anything, though. So the more important thing is that are you violating the location wise? So if the LCA is covering your home already, and now they are moving you to remote, which is covering your home right now, I don't have a problem with it.
Shubham says, can the spouse of an F1 who's on F2 stay in the US if a change of status to H4 is pending on October 1st? So I'm assuming the F1 holder is filing a change of status to H-1B, and the F2 holder is filing a change of status to H-4. And assume the H-1B gets approved in regular processing before October 1st, or maybe they upgrade to premium processing. Great. So now the F1 holder is on H-1B, but the F2 is still pending change of status to H4. That is not a problem at all. Even though you're no longer in F2, the F1, even though you're no longer in F1, the spouse can stay in the US based on the pending H4 as long as it is pending. No problem with that at all.
Emily, I want your opinion also in the birthright citizenship hearing that happened in the Supreme Court, though. Um, I am expecting a 7-2 decision in the favor of us against the government. Or I'm not surprised if it's going to come 9-0, though. That's the way I am thinking. What do you think? Because they're asking opinion of us.
Yeah, I agree. I think it's going to be a landslide against the government, given the long, long history of birthright citizenship in this country, and that you can't just change your interpretation of it. Um, yeah, I would agree.
What I
9-0.
also, yeah, 9-0 is what I'm thinking. I think so. What they may not even touch the constitutionality. They may just go to what Congress has passed in 1940s, I remember. They might just avoid the constitutionality because this is just against the Congress. So what Congress has passed, because after the decision of the Chinese gentleman, where they tried to deny the citizenship, the Congress has passed legislation legitimizing that particular instance. So So the Congress had an opportunity to change the language. They didn't change the language in it, so they legitimized. So I'm thinking they might not even touch the constitutionality at all. They may just pass on based on the Congress and issue the judgment. Yeah, I'm expecting 9-0. I will not be surprised if I get 7-2, which still is a victory for us. Um, is the priority date, final action date is expected to move in September? We don't know, but there may be some movement in October. Visa bulletin. That's because October is where the year starts, financial year starts for USCIS.
Kushal says we filed an H-1B change of status from F1 to H4 and H4 EAD in late March in premium processing. H-1B was already approved on April 1st, but my wife's status is saying case is transferred. Does it mean it's being bundled? No, it is definitely not being bundled, because if it was bundled, they would all three be approved together. So that means the H4 has been separated. The EAD will also be separated because they need to do the biometrics. So that's going to take even longer. So no premium processing on the H4 or H4 EAD, unfortunately.
We can't give a blanket address to the USCIS where to send the medicals. So we strongly recommend to have a consultation. Normally, in my consultation, I will see where you file the 485 application, where the 485 application has been transferred. If it has been transferred, if it's not transferred, where you would have originally been filing the 485. And I also draft a letter requesting from you, requesting the USCIS not only that you're sending the medicals, that your priority date for visa bulletin is current in the final action date in the month of April, and probably and also in the month of May, and they should adjudicate your application under EB2. So all those things, strong letters, I will draft it if you have a consultation with me, and you can block a time that is suitable to you at the bottom. My calendar is available there.
NRP says, my wife and I both have approved I-140s. I'm backlogged, but she's rest of world. So I can file as her dependent. But should we also file with me as the main applicant using cross chargeability? And we could then have two concurrent applications. You definitely can do that. There's no harm to it, and go with whichever one is approved first, especially if there's any, weird job things that happen over the next 6 months to a year while the applications are pending. If one of them, one of the jobs, gets unexpectedly terminated, you can still proceed with the other application. So I don't see any downside other than the extra cost.
Um, how long it's taking for the 485J to get approved for porting I-485? This question is coming from Sahai from YouTube. You don't have to wait for the I-485J supplement to be approved. Once you file the 485, if you want to move from company A to company B, the rule is that it must be more than 180 days before you move to company B, and it must be in a similar profession. There are a lot of people ask me a question. I moved to company B. I filed a I-485J with company B. Can I move to company C within 180 days? Absolutely, you can. It's only the first company that filed the I-140, that has the I-485, that filed the I-485J initially. That's a company you have to wait for 6 months. Afterwards, if you want to keep switching the jobs every 1 month, you can do so. Not a problem.
Sam says, is it okay to travel to India on H4 while my 485 is pending and I did not apply for the advanced parole? I mean, technically, yes. I'm assuming you have a valid H4 visa stamp, but we're in the Trump administration, so we're not recommending travel at all on H4, even if you have the visa stamp, because what if your H4 gets unexpectedly revoked while you are outside the US and you don't have an AP yet? You have no way of getting back into the US to pursue your green card.
People are asking with regards to the EB5, there seems to be a increased demand for EB5 in India category. there could be a backlog definitely in EB5 category soon for Indian nationals. So definitely that is something that can happen. Anything else, Emily? Before
Oh,
we go.
wow. We're already done for the day. Nothing from me. Thanks everyone for joining. Remember, if you want to know about options, if you are not selected in the lottery, join our webinar. It is free. It is Thursday, April 16th at 1 o'clock, and you can register at the link that has been provided.